The Federal High Court sitting in Abuja has affirmed the power of the Independent National Electoral Commission to deregister political parties which fail to comply with the provisions of the law, particularly Section 225A of the 1999 Constitution. The presiding judge, Justice Taiwo, in a judgment delivered in the suit filed by the National Unity Party, one of the 74 parties deregistered by INEC in February, declared that the constitutional powers of the Electoral Commission and the reason given by the Commission for the deregistration of parties are valid, in conformity with the law, and could not be affected by the fact of anticipated local government elections by some states which dates were not fixed, certain, or even known. The court therefore held that the deregistration of National Unity Party as a political party in Nigeria was lawfully done in exercise of vested constitutional powers of INEC in accordance with Section 225A of the 1999 Constitution. The judgment conclusively terminated the legal existence of the party and also all its other rights and obligations. The court also held that the party failed to show that the exercise of its powers to deregister the party was at variance with the law and also ultraviolates its powers. Hence, the court came to the conclusion that the plaintiff, which is the party, failed to prove its case, and the issues for determinations cannot be determined in its favor, and the reliefs it sought could not be granted to it. The court in the judgment quashed the argument of the NUP party, which has some legal argument by the 74 registered parties, that until a local government election in the country are held, instead of only FCT local elections that the Constitution empowers INEC to conduct, that INEC cannot deregister them. Prior to the deregistration, controversy have raged between the Electoral Commission and the 74 parties, with INEC holding the position that after fulfilling their constitutional rules of conducting presidential, federal, state legislative, governorship and the FCT council elections, that a stage was set for the registration of parties which did not win any position as required by the Constitution, a position that the courts have now upheld, thereby dimming the hope of any of the 74 parties regaining their legal right to exit. By this judgment, only 18 political parties will be participating in the Edo and Ondo state governorship elections scheduled to hold on September 19, 2020 and October 10, 2020. Lawyers are said to be of the unanimous opinion that with the finding of the court in the judgment, it will be extremely impossible for another high court to find otherwise, since from the deregistration template, basically the same issues were raised by INEC as grounds for the action they took to deregister the political parties. Lawyers say though a high court is not bound to follow the judgment of a court of coordinate jurisdiction, as it would have followed that of the Court of Appeal or Supreme Court, but the judgment will be persuasive and another high court judge would need to find a marked difference before it can deviate from the earlier judgment. On his part, the acting president of the Inter-Party Advisory Council (IPAC) and AAC party chairman, Dr. Leonard Nzenwa, said that until obtained on appeal, the judgment of the court is the position of the law, and only the 18 political parties recognized by INEC will participate in the Edo and Ondo governorship elections, and that the parties are ready for the elections. Efforts to reach the national chairman of the National Unity Party, Chief Perry Okpara, prove abortive, as his phone lines were off. While INEC is said to have started showing the willingness of the Commission to obey this judgment of the Federal High Court by their decision to have stakeholders meeting for the Ondo and Edo election with the existing and officially recognized 18 remaining registered parties that survived the constitutional hammer. Root TV, Nigeria.